Seventh order of the day is commencement of debate on the general principles of bill for an act to alter section 35, subsection 4 of the Constitution of the Federal Republic of Nigeria, 1999, as amended. Chapter C, 23, Laws of the Federation of Nigeria, 2004, to ensure that persons arrested for commission of crimes are promptly charged to courts of competent jurisdiction and are not unlawfully detained for other matters connected therewith. Honorable members will recall that the bill was read the first time on Wednesday, 27 January 2016. Now I invite Honorable Omoregie Ihama to move that the bill be now read the second time.
To alter section 35, subsection 4 of the Constitution of the Federal Republic of Nigeria, 1999, Laws of the Federal Republic of Nigeria, 2004, to ensure that persons arrested for commission of crimes are promptly charged to courts of competent jurisdiction and are not unlawfully detained and for other matters connected therein. I so move, Mr. Speaker.
That the bill moved by Honorable Ihama be read for the second time. I so second.
The Constitution of the Federal Republic of Nigeria, Laws of the Federal Republic of Nigeria, to ensure that arrested persons are promptly charged to courts of competent jurisdiction and are not unlawfully detained. Mr. Speaker, honorable colleagues, it is necessary that I bring to your notice that the provision court of law in section 35, subsection 4 of the Constitution of the Federal Republic of Nigeria, 1999, as amended, is vague in practice. Law enforcement agents have a common practice of arresting an individual upon flimsy allegations which have not been investigated and substantiated at the time of making the arrest, and are so not to violate the provision of section 35, subsection 4 of the Constitution, right to personal liberty. The arresting authority charges the individual before the magistrate court, and since the magistrate court lacks the jurisdiction to try the case, he also cannot grant bail. Unfortunately, the accused person is remanded in prison custody pending the issuance of the Director of Public Prosecution, DPP's advice, which would then make the accused person eligible for trial before a court of competent jurisdiction. That is, my honorable colleagues, the High Court. Thus, the arresting authority will be said to have fulfilled its constitutional duty by bringing a suspect before a court of law, albeit one without jurisdiction to try the offense alleged, while denying him the enjoyment of the rights of the law was actually enacted to protect. Mr. Speaker, honorable colleagues, I am not one of those cranks who delight in pitying the living at the expense of the dead, or who clamor for mercy for the prisoner and forget his or her victim. The system whereby suspects are just arraigned before a magistrate court on holding charge and are remanded in prison custody is not a fair act. To me, honorable colleagues, Mr. Speaker, is illegal and unconstitutional. Holding charge compels indefinite detention of suspects, and as such, contrary to our legal belief that an accused person is presumed innocent until proven guilty, as guaranteed by Section 36 of the Constitution of the Federal Republic of Nigeria, 1999, as amended. This is one of the reasons why we have extreme high rates of individuals who are awaiting trials in our prisons because they have not been formally charged before a court of competent jurisdiction. a situation that can endure for a decade and beyond. It is an insidious but pervasive practice which severely punishes the innocent persons. Mr. Speaker, honorable colleagues, very recently, in a publication, I have the copy here, by the Daily Trust newspaper of the 13th of January 2016, it was reported that the Chief Judge of the Federal High Court, Justice Ishaq Bello, directed magistrates and area courts to decline jurisdiction on any case not within their competent jurisdiction and send such cases to his office for reassignment to higher courts. The same publication, honorable colleagues, quoted the Deputy Controller in charge of Kefi prisons, Mr. James Lander, saying the prison with capacity of 160 inmates is now overstretched with 540 inmates, 415 of which are awaiting trial. Mr. Speaker, from these 415, we do not know how many are innocent of why they are being held because they have not been tried. It is a well-known fact that over 60% of our prison population in Nigeria fall within the class of awaiting trial. Anyone conversant with the Nigerian prison will know that the above fact is true, and this class of people suffer more than the convicts, because they are subjected to unimaginable indignity, even as they have not yet been convicted of the offense they are accused of. Mr. Speaker, honorable colleagues, now the question is, when will the trial ever come for those said to be awaiting trial? When the law of the land has left a window for an insidious procedure known as holding charge. It is an aberration and an abuse of judicial process for an accused person to be arraigned before a magistrate court for an offense over which it has no jurisdiction, only for the accused person to be remanded back in prison custody and not tried or properly charged before a court of competent court. It will be an infraction on the right to fair hearing and liberty of the accused person. Mr. Speaker, my honorable colleagues, the current practice where no serious investigation will be conducted instead, suspects will be arrested and detained for months to be taken to court on holding charge, is one of the factors responsible for the prison congestion today. There are so many cases where the suspects have no link with the crime. Perhaps the suspects were just apprehended on the street during the raid, and if there's no one to bail them, they will be charged to magistrate court based on holding charge, and unfortunately will be remanded in prison pending the outcome of the Director of Public Prosecution. This doctrine of holding charge has made so many innocent Nigerians suffer needlessly. Here is an illustrative example and a true life story. In 2006, one Taiwo Odeshola's handbag was snatched by a thief at Agege Ogba, Lagos. She shouted, "Thief," and thief. The thief was caught, and thereafter jungle justice was meted out on the thief by irate mob, which was beyond her control. The thief was killed, and she was then arrested by the police and arraigned on holding charge. Subsequently, my honorable colleagues, she was detained. The DPP's legal advice that exonerated her came too late, and behold, she died while on holding charge. Mr. Speaker, honorable colleagues, I think this bill is very straightforward. We have to amend this section of the Constitution to decongest our prisons and also to give opportunity to those held for one offense or the other to be charged directly to courts of competent jurisdiction to enable them have the right of fair hearing. I use this opportunity to urge my fellow colleagues that they should please support just this singular amendment that will help imprison the congestion as well as the right for fair hearing for our fellow Nigerians. Thank you very much, and may God, Allah bless all of you.